Hello and a warm welcome to World This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal Joon, Associate Editor, latestlaws.com, and I will be taking you through the significant orders and judgments passed by various courts in the country and some important international news from this week. Let's begin with Supreme Court this week. The Supreme Court, while allowing an appeal, granted bail to a man who is under prosecution in connection with the UAPA Act 1967 and observed that an accused has the right to speedy trial under Article 21 irrespective of the nature of the crime. A division bench of Justice J.B. Pardiwala and Justice Ujjal Bhuyan pointed out that over a period of time, the trial courts and the high courts have forgotten a very well-settled principle of law that bail is not to be withheld as a punishment. The Supreme Court clarified that Article 21 applies irrespective of the nature of the seriousness of the crime. The court referred to Hussain Ara Khatun versus Home Secretary, State of Bihar, 1980, in which the Supreme Court stated a valid procedure under Article 21, in which one contains a procedure that is reasonable, fair, and just, and a procedure cannot be reasonable, just, or fair if it does not ensure a speedy trial for the determination of the guilt of such person. Further, the court directed that if the state or any prosecuting agency, including the court concerned, has no wherewithal to provide or protect the fundamental rights of an accused to have a speedy trial as enshrined under Article 21 of the Constitution, then the state or any prosecuting agency should not oppose the bail plea on the ground that the crime committed is serious. The Supreme Court, while deciding on a matter where a portion of a plot which was designated as a panchayat ghar was reassigned for a residential use and allotted to different individuals, observed that if no period of limitation has been prescribed, statutory authority must exercise its jurisdiction within a reasonable period. What, however, shall be a reasonable period would depend upon the nature of the statute, right, and liabilities thereunder, and other relevant factors, a division bench of Justice P.S. Narasimha and Justice Aravinda Kumar observed. The Supreme Court has chastised high courts over the casual approach in deciding suspensions of sentence petitions. A division bench of Justice J.B. Pardiwala and Justice Ujjal Bhuyan emphasized on the law that if sentence imposed by the trial court is for a fixed term, then ordinarily the appellate court should consider the plea for suspension of sentence liberally unless there are exceptional circumstances emerging from the record of the case to decline such relief. The court expressed discontent with the order of declining the application by the High Court, said that no exceptional circumstances were observed by the High Court. Now let's have an overview of High Courts. The single-judge bench of the Jharkhand High Court has held that the provisions of discharge as given in the Cr.P.C finds its place depending upon the nature of the trial. It was furthermore held that in a case of serious nature, when it is a sessions trial case, for framing of charge, there should be a sufficient ground. The court observed that according to the provisions of Cr.P.C, the discharge provision is applicable based on the nature of trial under Section 227 Cr.P.C, sessions trial case under Section 239 Cr.P.C, warrant case trial by a magistrate, and complaint case under Section 245 Cr.P.C. It was furthermore observed that in a case of serious nature, when it is a sessions trial case, for framing of charges, there should be sufficient ground. The court relied upon the judgment titled Yogesh versus State of Maharashtra. The Allahabad High Court, while granting bail to a juvenile, stated that the gravity of the offence has not been mentioned as a ground to reject the bail, and it is not a relevant factor while considering granting bail to the juvenile. The court stated that under Section 12(1) of the Act, the prayers for bail of a juvenile may be rejected if there appears reasonable grounds for believing that the release of the juvenile is likely to bring him into association with any unknown criminal or expose him to moral, physical, or psychological danger, or that his release would defeat the ends of justice. The court thus noted that the applicant is a juvenile and was entitled to the benefits of the Act's provision, and further noted that the applicant does not appear to be prone to criminal proclivity or criminal psychology and does not have a criminal history. The single-judge bench of the Andhra Pradesh High Court has held that the notice is the first limb of the principles of natural justice. It must be precise and unambiguous. In the absence of a notice of the kind and such reasonable opportunity, the order passed becomes wholly vitiated. Thus, it is essential that a party should be put on notice of the case before any adverse order is passed against him. This is one of the most important principles of natural justice. The court observed that the audi alteram partem rule is often regarded as a fundamental principle of natural justice, that no one ought to be condemned without first being heard. It was furthermore observed that it is essential that a party should be put on notice of the case before any adverse order is passed against him. The Calcutta High Court, while dismissing a petition filed against an order passed by the tribunal in a contempt application and in a miscellaneous application filed in connection with an original application, held that once an order has been passed by a party to a proceeding on the basis of the direction issued by the court, there arises a fresh cause of action to seek a redressal in an appropriate forum, and such action does not constitute contempt. The court said that the direction towards compensation would depend upon the facts and circumstances of the case, and not straitjacket formula can be applied. No malefice can be attributed to the action of the respondents, and from the sequence of facts, it does not appear that the respondents were solely responsible for the delay due to pendency of the proceedings. The Patna High Court, in a petition seeking compassionate appointment, observed the well-settled principle that for compassionate appointment in cases wherein the employee becomes traceless, the legal dependent would be eligible only after declaration of civil death, which is after 7 years period, in accordance with Section 108 of the Evidence Act. Moving on to international news this week. The US Supreme Court has sided with the January 6th Capitol riot defendant in a ruling that could affect hundreds of prosecutions, including the criminal case in Washington against former President Donald Trump. Voting 6-3, the justices limited the Justice Department's use of a 2002 law that makes it a crime to obstruct an official proceeding. The majority said that the law, enacted in response to Enron Corp collapse, is designed to protect documents and other records and wouldn't apply simply to the act of trying to stop a congressional proceeding. Given that the law was enacted to address the Enron disaster, not some further flung set of dangers, it is unlikely that Congress responded with such an unfocused and grossly incommensurate patch, Chief Justice John Roberts wrote for the majority. The case divided the court along unusual lines, with Liberal Justice Ketanji Brown Jackson joining the majority and Conservative Justice Amy Coney Barrett joining the dissent. Japan's top court has ruled as unconstitutional a defunct eugenics law that saw 16,500 disabled people forcibly sterilized between the 1950s and 1990s. The Supreme Court also ordered the government to pay damages to 11 victims who were involved in 5 cases that were heard on appeal. Wednesday's landmark ruling brings to an end a decades-long fight for justice by victims who has been demanding compensation and an apology. After years of lawsuits, a 2019 law finally granted surviving victim damages, but some have continued to fight for higher compensation. The US Supreme Court has ruled on Monday that Donald Trump enjoys some immunity from prosecution as a former president, a ruling that will likely delay his trial for conspiring to overturn the 2020 election. The 6-3 decision, split along ideological lines, comes 4 months ahead of the election in which Trump is the Republican candidate to take on Democrat Joe Biden. Conservative Chief Justice John Roberts, in his majority opinion, said a president enjoys absolute immunity from criminal prosecution for official acts taken while in office. There is no immunity for unofficial acts, Roberts said, sending the case back to a lower court to determine which of the charges facing the former president involves official or unofficial conduct. The 3 liberal justices dissented, with Justice Sonia Sotomayor saying, "Never in the history of our republic has a president had been reason to believe that he would be immune from criminal prosecution if he used the trapping of his office to violate the criminal law. With fear for our democracy, I dissent," she said. In the end, we have miscellaneous news. The Allahabad High Court has expressed grave concerns over rising religious conversions occurring during gatherings and warned that if such a trend continued, the majority population of the country will become a minority one day. Justice Rohit Ranjan Agarwal made the observation while dismissing the bail plea of one Kailash accused of converting a group of Hindus from a village to Christianity. The High Court ordered an immediate ban on religious congregations where conversions of individuals are taking place, saying that such activities directly violate the rights to religious freedom as enshrined in Article 25 of the Constitution. The High Court said propagation meant to promote religion and did not mean to convert any person from his religion to another. It said it took note of the instances of poor being misled and converted to Christianity in various parts of Uttar Pradesh. The Jharkhand High Court has taken suo motu cognizance of an error in the Universal LexisNexis edition of the Bharatiya Nyaya Sanhita BNS Bear Act and directed the publishing house to publish a corrigendum in all national and regional newspapers. A division judge bench of Justice Anand Sen and Justice Subhash Chandra took note of the editions of Universal LexisNexis and International Law Publishing House of the Bharatiya Nyaya Sanhita 2023 Bear Act, which with its short notes have major errors in section 1032 on the sections about lynching and has been wrongly reproduced. This, the bench said, could have serious implication for the interpretation and application of the law. The court took exception to the LexisNexis version, which uses the words any other ground instead of any other similar ground. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.